If you're going through divorce, you might be wondering how you get full custody of a child in California. And, I want to be clear that this analysis is not based on what you want or what your ex wants. It's based really on the best interest of your child. If you believe it's in the best interest of your child for you to have full custody, here's what a court's going to look at. A court's going to look at, which parent is more able to take good care of your child. And if you're both able to take care of your child, then you're probably not going to get full custody. Some reasons why you could get full custody is if the other parent has some behaviors that are causing a danger to your child. This could involve substance abuse. This could involve having abusive behavior or extremely neglectful behavior, or, that the other parent is not able to really put your child's best interest and making it a priority. Maybe the other parent is not able to get your child to school on time or doesn't take your kid to school. Maybe the other parent doesn't do your child's homework with him or her after school, and he or she isn't prepared for school or isn't clean and have what he or she needs for school, or, at the parent-teacher conference, the teacher has commented that on the days when the other parent has your kid, your kid's having a really hard time. Maybe your kid has been having meetings with the counselor at your child's school, and the child's counselor has reported that there's a problem at home with the other parent. You should keep in mind that these counselors are mandatory reporters for CPS, Child Protective Services. So if there is a problem at the home of the other parent, it's pretty important that you do something and you say something, because, if there's a report made to CPS, your kid could be taken away from you too, because if you don't do anything about it and you just sit and you're letting this happen, they could find that you're part of the problem too. And we don't necessarily want that to happen to you, because if you're a good parent that cares about your kid, which is why you're watching this video, you're trying to do all you can to protect your kid and do what's in his or her best interest. So if your kid is having a hard time, and they're having a hard time emotionally, or you think they're being physically abused, or you think something's happening in the other parent's care that's really putting your child in danger, I really strongly recommend you schedule a consult with an attorney on my team so we can walk you through your options, and you can make the right decision and do really, what's best for your child. Because at the end of the day, it's not just about protecting you from, a CPS investigation or something like that, right? You're coming to us because you're really worried about your kid, and you want to do what's best for your kid. And if getting sole custody is what's going to be best for your kid, then we'll review all your evidence, and we'll talk to you more about your circumstances, and we'll tell you kind of what we think the court outcome may be and what we think you should do as far as roadmaps for next steps ahead. If you're looking to get temporary custody of your child in California, we would talk to you about what circumstances are arising that would merit us filing potentially a motion with the court to get temporary custody. Now, I want to be careful and make a distinguishment to distinguish between temporary legal custody and temporary physical custody. So legal custody involves, your rights to make decisions about your child's health, safety, and welfare, where they're going to go to school, where they're going to go to the doctor, what kind of treatment they're going to receive, that kind of thing. Physical custody is the actual amount of time and the days, your kid is with you. So usually when people come to my office and they want temporary sole custody, they want temporary sole physical custody. They want the child to be in their care 100% of the time because they're worried about the other parent's behavior around the kid. And the other parent's behavior could range, right? Maybe the other parent is physically harming your child. That's kind of easier to assess, maybe with physical abuse. And when that's happening, it's more straightforward for us to really work with the client and decide that, filing a motion with the court is the right next step. But maybe it's emotional abuse, which might be a little bit more nuanced. Maybe the other parent's yelling at you in front of your kids, or yelling at your kids, or doing really extended timeouts, or, making threats to your child, or making threats to you in front of your child. Sometimes what people don't realize is even throwing objects is really, it can be considered abuse in California. Like throwing a chair, or throwing an object that grazes by someone's face. There's all different kinds of behavior that can really be determined to be unsafe. And it's not just based on the behavior, behavior, but also on how that behavior is making you feel, and more importantly, making how that behavior is making your child feel. And sometimes this is an awkward kind of question, and it's uncomfortable because, we ask our clients, is your child exhibiting any behaviors that make you believe that your child is suffering harm? And then it kind of causes you to think about these things that maybe you've been trying to suppress in your brain because you haven't want to deal with it. But, maybe your child has started doing self-harm, where they're, hitting themselves in the face or hitting their head against the table, or they're doing things that just starting to have these kind of tics and behaviors. And that can be a response to having a really an unhealthy dynamic at home. Maybe your child has started acting out at school. The teachers are starting to ask you about it. Like these things kind of have this trickle down effect where your child will start having these behaviors, and maybe it's hard to know what's going on, but maybe you have the intuition to know it's something going on in the other parent's behavior that's really inappropriate, that's impacting your child. And if your child is suffering detriment while with the other parent, or if the other parent is, having a substance abuse issue or some kind of, and the substance abuse is causing them to have behaviors that are unsafe around your kid, like driving your children under the influence, or, having harmful behaviors with your kid, all parents aren't equal, right? And being married to a parent that has a substance abuse issue or a behavioral problem or is very neglectful around your children, that doesn't mean that it's your responsibility to prop that parent up and make them into a good parent and protect your child. Oftentimes the best course of action is to either have your attorney negotiate an agreement with the other parent so that, they get the help they need. But if that other parent's unable or unwilling to get the help they need, then sometimes court action is, your only choice. We have a lot of clients with high performing or spouses that are high performing, alcoholics or have other substance abuse, but maybe they still are able to maintain a really high profile job, and, maybe nobody else knows about the substance abuse. But unfortunately, where it's really going to seep out is during their parenting time with your kids, right? And you really don't want this to impact your child. You really want to do everything you can to protect your kid, right? Because if you're not going to, who else will? So if you're looking to get temporary sole custody of your kid, please don't wait. The longer you wait, the more the other parent's behavior, you're kind of treating it as acceptable and you're normalizing it, and it becomes less of an alarm, because the court might see, well, you haven't done anything for a month, and she or he has been drunk around your kid. Why now? And let's not go there. Let's react to urgent emergency right away. And if you don't know if this is an urgent problem, you don't know how seriously you should take it, that is a really good reason to meet with a divorce attorney right away, to know what you should do so that you react in the right proportion to the problem that's happening in your life to your kid. So you might be wondering, how do you win a child custody relocation in California? Maybe you're looking to move your child to another county or another state or even another country. And this happens all the time. What we call move-away cases or child relocation cases are very common in California, especially in the Bay Area. A lot of parents want to move their kids from San Francisco to one of the suburbs because, they want a bigger home, and they want to keep their kid in public school, but put them in a better public school so they can put the money on the house and vacations and whatever else you want to do to enjoy your life with your kids, right? Or maybe you want to move out of state because California is an expensive space to live. Or maybe you found a really great job elsewhere. You want to move in with family for more support. There's all different reasons to relocate with your kid. And relocations are granted oftentimes by the courts. But, how to win your child relocation case, what is your evidence, right? Because in California, if you and the other parent aren't going to agree on where your child's going to live, then it's going to need to go to court and be litigated. And if it's going to be litigated, the judge is going to look at the evidence. And you might think it's a slam dunk because you're the primary parent and you've always been the primary parent, so obviously your kid should get to move with you. And maybe you're right. Maybe it will be a slam dunk, but we don't know yet. We have to review all of the evidence in your case. And the evidence involves your testimony, which is kind of a slam dunk, right? Because you just have to talk to the judge. But it's something that will help you prepare in advance and go over with you so you're comfortable. And, we'll make sure whatever it is that you want to testify to is information that is going to, have probative value in your case. It will also be the other party's testimony. Also, there might be text messages or emails or pictures or videos. There's all kinds of documentation and information that can be used as evidence in one of these trials in order for a judge to review it and determine what's in the best interest of the kid. The judge will look at where's your child's network of support. If your child has a lot of friends and peers where he or she lives now, and you're trying to relocate your child to somewhere where you don't know anybody, that could be against you. Where's your friends, your family live? Do you have family friends with similar age kids? What does that look like? What is your kid's daily life going to be like? What kind of support is she or he going to have? Where is he or she going to go to school? Is that school going to continue to support his or her needs? Does your kid have any special needs? Is he or she on the IEP program? Like, what are we looking at here? If you have a special needs kid, that's a more tricky situation to relocate a special needs kid from his or her, place where he or she's had this stable community and support system. But maybe there's more resources where you're moving. I don't know, right? We have to look at all of our options. A lot of times in these move away cases, a child custody evaluation is involved. A child custody evaluation involves the retaining a child custody evaluator, which is a mental health professional whose job it is to assess each parent with the child to see kind of how that parent's attachment is and how their relationship is with the child, as well as speak to collateral contacts, which are third parties that have witnessed your child communicate in their relationship with you as well as your spouse. The child custody evaluator may also speak to the child's teacher or people involved in the child's extracurricular activities or other family members to really get a holistic understanding and make a decision as far as what is in the best interest of your child. Not all child custody evaluators are created equally, and we can't always predict what the evaluator's outcome is going to be. But a good family law attorney on my team is going to maintain that really important rapport and relationship with the child custody evaluator and, second guess them when they're saying things that aren't quite right and keep them on, up to par so that we feel some semblance of control of this process, because it can feel kind of daunting and scary. And we want you to know we're always one step ahead. We're getting all the details right, and we're always on your side. In the unlikely event the child custody evaluator doesn't make orders in your favor, we can always hire a consulting child custody evaluator. But it's our job to be one step ahead and carefully review all the evidence in your case and give you the tough love and tell you if you don't have a case or tell you if litigation probably isn't the right answer. And if there's a possibility of negotiating a settlement through a private mediator, through a private judge, or this between attorneys, we'll talk you through what that looks like. Doing a trial on a child relocation case or move away case can be very expensive. There's one factor sometimes that can come at play, which is if the other parent will not cooperate in facilitating your visitation with the child. If that is a component in your case, please tell us about that. Let's talk to you about that. There's case law that says that if the other parent isn't facilitating your parenting time, that could be a reason for the court to order that the child stay with you if you're moving. It's not always a reason. We can't be certain that's how the judge is going to rule, but we want to look at all of these important factors to do an analysis to help you decide, is it worth it to try to go for this move away request? And you should know that if you file a request to move away or relocate with your child, the court is always going to assume that you are going to move to this new place, whether or not your kid is going to get to come with you or not. So if the court assumes that you're going to move, the judge is going to make an assessment of, is it in your child's best interest to stay with the other parent in the Bay Area? Or is it in your child's best interest to move with you to this new location? So you should know that going in. As you can see, this is a pretty complex process that the court takes on, and also the child custody evaluator, if a child custody evaluator is appointed by either the court, or, paid for by you. So, it's really important to get a family law attorney involved. I really don't recommend doing this by yourself as a self-represented party. It doesn't really go well when you do that because judges are used to talking to attorneys. And when you try to advocate for yourself on these complex trials, you don't know how to put forward the evidence and make sure it's admitted properly to the judge. And you're likely going to sabotage your case as much as you don't think you will, even if you're an attorney, even if you're a family law attorney, you should hire your own divorce attorney or family law attorney to help do this right for you. So if you're thinking of relocating with your child, please contact my law firm, Fenchel Family Law. We'll schedule you for a consult with one of our very experienced family law attorneys so we can walk you through this process and help you understand your options.